I'd like to share with you some common misconceptions about estate planning. Maybe one of the most common is, I am too young, I don't need an estate plan. Well, let me ask you, are you 18 years old? If so, you are an adult. And if you are an adult, you need an estate plan. You might say, well, I don't need an estate plan. I don't need a will because I don't have any assets. And that may be true. But you may encounter some form of accident, sickness, or disability. And for that, you need what I call the living documents. Those are your durable powers of attorney for finances, for health, and your advance directive living will. Those are called living documents because they protect you during your lifetime if anything should happen to you. If anything happens to you where you can't manage your own affairs, your finances, okay, you might say, I don't have any finances. Okay, let's move on to health. If you can't make any healthcare decisions for you, well, who will do that? And who will make the decision if you are on life support, for example, to remove that life support? I don't know who remembers the very sad situation of Terry Schiavo out of Florida, but she was young in her 20s and she did become incapacitated, and she was married, and her husband and her parents could not agree about what her medical treatment should be. And so this was very much in the public eye. Very sad from any perspective that you look at it. What can a person who is a young adult do to make sure that they are never a part of a court guardianship or in the news for what their care should be? Have your living documents, your durable powers of attorney for finances, for health, and your healthcare directive / living will. If you have those, then you will never be in the news for a fight that your family will have about what is the right thing for you. The court will never become involved. The Florida legislature will never be involved. So even if you are young and have no assets, you still need estate planning documents. Another misconception that people have about whether or not they need an estate plan and thinking that they don't is that they don't consider themselves wealthy. Well, what is wealthy? Do you have any assets? Do you have a car? Do you have a bank account? Are you working? Are you contributing to your retirement account at work? Do you have a home? With our real estate market, lots of times the value, the equity in your house goes up much more than what your mortgage is. So let's say you don't consider yourself wealthy, but you do have assets. Think about if you were to die young, where would you want those assets to go? Obviously, if you have children, that's one thing. You want to make sure you provide for your minor children. You want to make sure that you have a will that appoints a guardian for your minor children. But let's say you don't. Let's say you're single. Would you rather what assets you have go to your parents, or would you rather that they go to your sibling, your favorite sibling, for example? If so, you're going to need a will. How complicated your estate plan is uncertain, unknown. I can't tell you that. Everybody's situation is different. I can say that if you don't have a very large estate, taxable estate, then it's likely that your estate planning documents are going to be more simple than somebody who does have a lot of assets. But that doesn't mean you don't need an estate plan. If you want to make sure that whatever you've worked hard for goes to the person you want to receive them, even if it's only a matter of $20,000, $50,000, $100,000, whatever the case may be, then do make sure you see an estate planning attorney to get those documents in place. This is a really common misconception. I have a will, therefore I don't need a probate. No, those two things are not equated. If you have a will, you may need a probate. A probate is the legal process to prove the will and to make sure that the will is in effect and the assets, your estate, pass under your will. Generally speaking, think of it this way. If you have a will, you will have a probate. Probate is a legal process, as I explained. But keep in mind that if you've worked with an estate planning and elder law attorney, the fact that you have a will doesn't necessarily mean that there will be a probate. The will is the safety net that covers what will happen with your assets. But oftentimes what we will do is we will draft the will that says where the assets go, but then we will set up the estate plan to avoid probate if probate is not going to be of any benefit to anybody. So for example, let's say that you have a house and you want your house to go to your child. We'll do a transfer on death deed on the house, no probate. You have a bank account, pay on death to your child, no probate. An IRA, 401k, life insurance, beneficiary designation to that person. So with an estate planning lawyer, you can set up your estate to avoid probate if that is what is best for you. But don't fall into this trap, this misconception that says, I have a will, now there's not going to be any probate. No, those things are not true. If you have a will, you may need a probate, you may not. And if you have any questions or you're confused about this, I would say seek out your attorney who prepared that will for you and ask these questions. I have a will, does that mean I'm going to probate or my estate's going to probate? You deserve to have an answer and a really good understanding of your estate plan, so I encourage you to ask those questions.